So I'm Wendy Jacobs. I direct the Emmett Environmental Law and Policy Clinic here at the law school, and with me is my colleague Shaun Goho, who's the deputy director of the clinic. And we're just so happy to welcome everyone here today, both you and our wonderful panel of guests. It is the goal of our session today to bring these national monuments to life and to consider them from a variety of perspectives, not just as the subject of controversy and litigation. So we're going to begin the session with a gorgeous short video of one of the monuments, the Bears Ears Monument in Utah. And it's a gorgeous video that was prepared by the Friends of Cedar Mesa. It's about 4 minutes. We'll start with the video. Then throughout the session, as we've already started doing, images of many of the other monuments will be on a continuous loop to remind us of their staggering beauty and diversity. After the 4-minute video, distinguished Professor Charles Wilkinson of the University of Colorado will speak briefly about the history of federal regulation and management of the monuments under the Antiquities Act, which we've all been hearing about in the news. It's the basis of both the declaration of the monuments and the Trump administration's efforts to cut back on the monuments. Professor Wilkinson has written about 14 books, I think, on law, history, and society in the American West. And he's a real expert on federal public lands law, so we're very lucky to have him here today. And he actually worked on the creation of two of the monuments, the Grand Staircase Escalante Monument, which was declared in 1996, and Bears Ears, which was declared in 2016. Charles will be followed by leaders of the Ute Mountain Ute and the Zuni tribes, who will speak about the spiritual, cultural, and historic significance of the Bears Ears Monument for their tribes. And we're so excited to have them here today. So we have Ms. Regina Lopez-Whiteskunk, who is a former member of the Tribal Council of the Ute Mountain Ute, and she was co-chair of the Bears Ears Intertribal Coalition, which was hugely important to the successful proclamation of the Bears Ears Monument. And it was a coalition of 5 tribes who, under other circumstances, don't always agree, but came together to agree on the importance of this monument. Since her childhood, Ms. Lopez-Whiteskunk has been helping to educate people through song, prayer, and dance, and she will give us a taste of that today. And she joins us today after participating in meetings at the UN in New York. We also are very fortunate to have with us today Mr. Carleton Bowekaty of the Zuni, who was also a key leader in the creation of the Bears Ears Monument and co-chair first of the Bears Ears Intertribal Coalition and then of the Bears Ears Commission. And we owe special and separate thanks to Mr. Bowekaty because he is also an Army veteran who has served 3 tours of duty in Iraq and has won a number of medals for his service. Then we'll hear from Lois Schiffer, who will speak about the history of the litigation around the monuments. And Lois is one of the graduates of this law school whom we are here to honor today. She has dedicated her long career to the protection of natural resources and the environment. Not only was she a key litigator at the Department of Justice for a number of years, but she was my mentor, and of that I'm very proud and very grateful. And along the way, she rose to become the Assistant Attorney General for the Lands and Natural Resources Division, now known as the Environment Division, at the Department of Justice. And later, she was General Counsel of NOAA. And for 30 years, on top of all of that, she has also taught environmental law at Georgetown as an adjunct professor. And although she is now technically retired, she is still a tireless advocate for the country's natural resources. So we're very lucky to have Lois here and as a graduate of this law school. Following Lois will be Ethel Branch, who is the Attorney General for the Navajo Nation. And Ethel is another of our fabulous graduates. And she, too, has dedicated her career to public service. Now she is the Attorney General, the Chief Legal Officer for the Navajo Nation, with a broad portfolio of responsibilities ranging from public safety to white-collar crime and protection of tribal natural resources. Her office is one of those that filed a complaint to protect the Bears Ears Monument. Finally, two of our clinic students, Caroline Cox and Iris Zhou, will speak about the work that they're doing with Shaun and me in the clinic to advocate on behalf of 3 of the monuments that are under attack by the Trump administration. So this is going to be a fabulous session. We're going to save some time for questions and answers, which will be led by Shaun Goho. But now we're going to quietly enjoy some of the images of these spectacular natural resources.
Well, Wendy, we all thank you for your introductions, and to you and Shaun for organizing this session. We appreciate it very much, us out-of-towners. And what Bears Ears, one of the things Bears Ears is about is the Puebloan and Navajo and Ute leavings from their pasts, their deep pasts, sometimes as much as 10,000 years, that are still there. And I will say that for those of you who are backpackers or just like a good hike into wild country, a day hike, there is no experience I have ever had that brought out the profundity of life to me than these ancient dwellings and homes and villages, entire villages that are still there. And you come around a corner on a trail and there it is, and it seems impossible, but it's not. And this country that the video showed, and the broader area of the Four Corners, the Red Rock country, the canyon country of the Southwest, is the place where the Antiquities Act began. The specific problems that the Antiquities Act of 1906 addressed with great speed and decisiveness. And what was happening was that in the late 1880s, local cowboys came upon some of these villages. Many of them are now in Mesa Verde National Park. And they were enthralled with what they saw. And then they started borrowing things, bowls, pots, sandals, clothes, and selling them locally. And then they turned to grave robbing and taking out ancient skeletons. And it, in a very short period, and it's been interesting to look at this, within about 6 or 7 years, it had become big business. And so wealthy people and museums from the East Coast and from Europe created a really substantial market for this. And the destruction of these villages increased dramatically. And at this time, when science was starting to come into public policy in a way that it never had been before, there were many archaeologists out there doing the research and reporting on the wonder of these places, but also on the sometimes, and maybe you ought to say often, grotesque leavings now with bones scattered around the area. And so the largest anthropologist reports came in the late 80s, in the late 90s. And it wouldn't seem to us today that this kind of activity in such a remote area, all these states were still a generation away from statehood even, that somehow Washington could be moved quickly. But it was, and it did happen quickly. And the AAAS was an organization that had been founded in the 1840s. It had kind of gone into a lapse of several decades. But the American Association for the Advancement of Sciences, by the late 1890s, was really active. And it brought forward a bill in 1900. And it wasn't strong enough. The commissioner of the General Land Office didn't like it enough. And then John Lacey, congressman from Iowa and chair of the House Public Lands Committee, one of the greatest conservationists in the House or Senate ever. The Lacey Act is named after him, commonly today an important wildlife statute that's still much in use. And for a couple of decades, the Wilderness Act itself was called the Lacey Act. But finally, people got their senses and I guess had to dispense with one or the other. And so now we have the Lacey Act of 1890, the Wildlife Act, or of 1900, the Wildlife Act, and the Antiquities Act. Between them, Binger Herman, the commissioner of the General Land Office, but particularly Lacey, made the proposal from the AAAS and otherwise stronger. And they put forth language that became the basis for the 1906 Act 6 years later. It sat for a while, but now we were at the absolute apex of the Teddy Roosevelt era. He had, of course, come in 1901. And the progressive era, which extended from and this is, of course, rough, but from 1890 to 1920, was really the first time the country had turned strongly to conservation. And the progressive era affected the public lands greatly, but it was general public policy because the concepts were conservation, science, efficiency, and using federal expertise to pass and administer legislation. And so this was a time when and it's interesting to look back on this time, where scientists had real influence in Congress. And when something came forward as proposal from the scientific community, there was real interest in it. And so in this, the only other era you can compare in environmental law with the progressive era is the upswelling in the late 1960s and early 1970s. But this was the foundation period, and this is one of the foundation statutes that allows for prompt action and decisive action and permanent action. And so we don't, apparently, well, we don't have any written knowledge that TR was involved in the actual legislative process, but Lacey was referred to as TR's right-hand man. And so one can guess that Roosevelt was involved, but we don't have that for sure. What the act did was it required permits to do any excavating or taking out of any objects, made it federal crimes to do either of those things, and then in a two-sentence section, which is the section on presidential authority to create national monuments. The two sentences are long sentences, but they allow presidents to create national monuments for objects of historic and scientific interest. That broad statement, almost the first words in the Antiquities Act, this section, are the president in his discretion And as Lois will report, those words in his discretion are, in a certain sense, the three largest words in the Antiquities Act. And it was required, sort of sternly, that presidents have to are limited to for monuments to the smallest area consistent with the proper care and management of the area. And so the act went out, and to understand the Antiquities Act, it seems to me you have to understand the roots of it, which is the country you're seeing here. And one of the largest and most important sub-regions in the Four Corners area is President Obama's proclamation, and then the statute itself, and then the early work TR did, because he did declare the smallest area practicable. He was really faithful to that, and he stood on the south rim of the Grand Canyon and looked out over it and said, 800,000 acres. We have to have it in order to have a national monument. The early legislative history was calling for units of 640 acres. And he hit 800,000 and then did 18 more monuments. And the Antiquities Act was launched upon the world. Thank you.
Good afternoon, everybody. My name is Regina Lopez-Whiteskunk. I'm a member of the Ute Mountain Ute tribe. I'm of the Uinta and Weemanooch band of Utes. I was born and raised in the southwest corner of Colorado. What does that mean? That means in a matter of minutes, I could be in Utah, I could be in Arizona, and I could be in New Mexico. So when we speak to the region, many times we get this convoluted view of what state lines, county lines, and reservation lines mean. For many of us, it's a definition of our voting districts. It's a definition of what state that we're citizens of. But even more importantly, it defines many Native American indigenous people of their boundaries. Let that not confuse you with what was formerly our home territories, hunting and gathering grounds, because that was a substantially larger area than what any boundary, state line, county line, or reservation line includes. What does that mean to my people? In this day and conversation of public lands means a lot to Native Americans, because that's the area that we can still access without infringing upon private owners of those swaths of lands that exist bordering our reservation lands today. We legally can be on those lands to conduct and mimic those same behaviors of our ancestors We can gather, we can hunt. When we gather things, we don't gather it just the food to survive on from day to day, or the fuels of collecting wood so that we can heat our homes and cook. But it's also a place where we can collect medicinal herbs so that we can carry on those ceremonial practices that have long existed well before many of us. Of course, before many of the reservation lines, anyway. The song I sang actually comes from a song that my father had sung to my brother and I many a times while we were traveling. And he called it the Dream Song. And I didn't know why he called it the Dream Song. But as I grew up and as I served my people in an elected capacity, then I began to understand what that meant. Many times we visit places in our dreams. Many times our elders and ancestors come to us in those dreams, and they take us to these sacred places, and they give us a lot of explanation, which explains our existence. So when you go out and visit sites of ancestral people, their moccasins and their footprints have been left behind. Many of us feel those. Many of us come along and we mimic those behaviors that either they did in their daily use, providing duties for their family, ceremonial, dances, songs, collection of herbs. But more importantly, what does public lands mean to us today? It not only means that I get to access it as an Indigenous person, but it also means that you have the right to access it as American citizens. This is a very important issue to not only the Indigenous people of the lands, but it's important to each and every one of us. It's absolutely important that we let our elected leaders know beyond those who do and support it, but it's the ones who don't have the education of why it means so much to the rock climbers, to the hikers, to the Indigenous people of this land. Many ask, what can we do to help? You can reach out to those individuals and those leaders, your neighbors, and ask them, do you know about how important this conversation is? What it means to many people, to myself? I have the honor to stand here and tell you my story because my ancestors have left a wonderful heritage behind for me to continue to speak of and to teach my grandchildren. I have that honor, but more importantly, I have that duty and I have an obligation for the next 7 generations. And when we say that, what does that mean? I can see 2 generations today when I go home. But the generations I can't see, those are the ones that I fight hard for. They're the ones I pray that will have the same honor, the same duty, and the same obligation to do what I've done traditionally as a Ute woman, but even more importantly, what I do as an American citizen, with all rights reserved. I have the same rights as anybody does, but I have duties and obligations to my Native people and my family. Charles spoke of something very important, the Antiquities Act, the one tool. What does this mean to my people? The Ute Mountain Ute people in specific regards. In 1906, it was Mesa Verde that was taken in the best interest of the people to protect and preserve. That was a part of what was designated at that point as Ute Mountain Ute tribal lands. So in the best interest of the people to protect and preserve that land and that tool was used in the best interest of my people. December 2016, President Obama, after many years of data collection of a grassroots organization named Utah Dinebekea, bringing to light the scientific and indigenous knowledges together, reached out to the tribal leadership of many tribes, and the 5 nations rose and said, we will be that sovereign voice. We will do the work. We will go to Washington, D.C. I had that honor to be amongst those voices. And in the best interest of our people, initially, which is what we set forth with, it became in the best interest of all people that we advocated for the protection, continued use of the land, and the ability for us to access it in our own way, in our own time, in our own space. Represented the day that the 5 indigenous nations of that region utilized a tool to protect and preserve in the best interest of all people. And I ask, what is so wrong with these 5 little tribes coming out of the woodwork and saying, we're going to use this because we can? And instead of it being used in the best interest of us, we used it in the best interest of all. It was a glorious day when we got that phone call and said it's going to happen. Although you're not going to get 1.9, we will give you 1.35 that will be designated. I said, not too shabby. I can do the math. It was pretty impressive that day. And I do have to say, I celebrated all for about maybe not quite 5 minutes, and I was already on the phone with Charles. And I said, Charles, I know we're getting this, but what do we got to do now to defend it? And he says, Regina, just celebrate. I was already on the defense. I was ready to dig up the war hatchet and say, let's go to D.C. right now. But we are where we are, and we continue on in grace. Through people like yourselves to continue to better educate one another. And I appreciate all the efforts and the support, but even more so, we never travel or do anything on our own. We have people, we have our ancestors, and we have a great team of support that always continues to help us along the way. And I say thank you. Thank you for all your support, your blessings, and continued prayers.
Good afternoon. My name is Carleton Bowekaty. I'm an elected member of the Zuni Tribal Council, and I'm honored to be here to speak on the issue of Zuni's, I guess, what ties we have to the sacred area known as Bears Ears. And I guess to properly address that, I will need to go back a little bit into Zuni's efforts into not only just repatriating cultural items, human remains, but also in our own efforts to make sure that we make sure that we take care of what we know we have. The first time that the United States Army approached the Zuni tribe, it was to ask for supplies, and we sold them supplies. We sold them corn, sold them beans, we sold them staples. And that was the very first interaction that Zuni had, our government had with the U.S. government. And it wasn't to ask for help, it was to offer help. 2-3 years later, they came back again and said, do you have more staples to sell us? And we said, yes. The last time you came to us, we had 2 years worth. This time we have 4 years worth. because we knew we would continue that relationship. We've continued that relationship with the Spanish government, the Mexican government, and eventually the U.S. government. And it was always the intent to make sure that we took care of our lands, we took care of our people. The evolution of that is that we now have CFRs. We are now included as consulting parties. But that was always never enough. I don't think it was ever enough for any Zuni tribal member to say, you know what, it's okay for you to come talk to us. No, it turned into, come and talk to us, and now we can teach you and educate you on how to do things correctly. To treat each other correctly, to treat the world correctly. Because you have to understand that we felt that there was, if something was going on wrong with the world, if something wrong was going on in Zuni, then we felt that the world was in balance. You know, when we hear about original Americans, you know, people even arguing like, are you patriotic enough? Our origin tells us that we emerged directly from the earth, came out into the Grand Canyon, made our way to eventually where Zuni is in New Mexico. We border right along the line of Arizona, and so our Zuni heavens are in Arizona. If we go back in history, there's probably one instance where the Zunis did not make their annual pilgrimage from Zuni, Halona, Itiwana, meaning the middle anthill in the middle of the world, out to the Zuni heavens in Arizona, and that was when the Spanish came. Other than that, every 4 years we make that pilgrimage out there. And some of it passes through state land, some of it passes through BLM land, federal lands, and some of it's private property. We've had ranchers approach our cultural practitioners with guns on horseback saying they can't fulfill this role that they've been doing forever, for millennia. So we educated, and now that we've kind of evolved and being able to process some of our resources, we're able to go back and buy sections of that trail and say, you're going to go on that trail and nobody's going to stop you because it's that important to you. And I guess when I look at my history as a veteran, 3 tours in Iraq, 39 months, to see the evolution of places that are so old and so historical, and to see it bombed, destroyed, because of human interactions that don't quite match out. Politics, you know, those type of things that at a base level we are passionate about, but doesn't make us better as humans, does it sometimes? One of the things that I saw in here was that when legal isn't moral. And I think that's what we face in this situation, when we feel that legally, in this situation, the president didn't have the authority to reduce the monument. And we feel that not only was President Obama legally and morally right in designating this area as a national monument, with collaborative managed built in with the tribes, we felt that was both moral and legally right. And so we've entered litigation, and we continue to defend that position. And as many headaches as we had, and Charles and Regina can attest to this, as many headaches as we had approaching the Obama administration on making this a national monument, going through the process of our proposal for a national monument. 5 tribes sitting at the table discussing these things, going word by word in this proposal, trying to convey, I guess, the cultural importance, which from our own languages, in my case, the Zuni language, into something that's recognizable in English. You know, we've kind of been pushing in the formation of the Native American Grave Protection and Repatriation Act. Zuni had an integral role in that. We were doing repatriation of our war gods long before NAGPRA was formed, contacting museums through ambassadorship and goodwill, more or less being able to make those connections and in a way let them know that it wasn't morally right for them to have these items, and they gave it back to us. And slowly we've been pushing for returns of these items. And so when we look at collaborative management, why is collaborative management important in the Bears Ears Intertribal Coalition's proposal to the president? One, because we wanted to make sure that land use techniques that the tribes have had for millennia continued in this area. And we understand that. And we got to the point where we understand if it was part of the law, then whoever the superintendent was, whoever that person was that's going to manage the monument, they would have to comply with that. Because we've gone through evolutions of superintendents or federal career persons that come into the area, and it's a re-education process that we feel as tribal leadership trying to convey to the federal agencies that what we feel is not only their duties, but I guess in their to morally be able to address this in a way that we need. We need to be able to share those values. And so one of the benefits is that when we did site visits with the Utah Office of BLM and then the Manatee LaSalle Forest Service, Ed Roberson is the manager of the Utah BLM. He used to work in New Mexico. So immediately we could make that connection. So I built on the relationship that my other Pueblo leaders have worked on and continue that. And I guess that's where we ask for your help. That's where we need your help. Make sure that we continue to define these values, define these things, and find out what's legally right and morally right, so that way we know that these things will stand. And that is why we understand, that is exactly why we believe that President Trump's action will eventually be declared illegal, and that we will get back the National Monument with collaborative management built in. Because that is exactly what we wanted, and that is exactly what we envisioned, and that is exactly where we will go. Because it's not in me to give up on this. It's not in me, not in my tribe to give up on this. For example, Navajo Nation, the Zuni tribe, we just got out of a 20-year contract support settlement with the BIA and IHS. Those are long, long cases that we took on, hoping that would be successful. And we were successful because of people that were able to help us and define what was legally correct. And we adjusted to make sure that it fit what we needed to in our tribal viewpoints. So if there's anything I hope to convey is that I don't look my time as a veteran, not just defending the country, but coming back. I know that what we have in Zuni, what our tribes contribute to the fabric of the society of the United States society, is that it's one of those fibers that once it's gone, it can never be replaced. We will never see certain things again. We will never feel certain things again. When my grandfather passed away, he was over 90 years old, a rain priest for much of his life. And immediately, it was like a star going out in the sky of Zuni knowledge, a big one. Maybe even a whole constellation was gone when he passed away, because there was so much in here that he knew that my time in the military took me away from that. But that's okay, because I did exactly what he wanted me to. Make sure that we took care of our people, took care of the knowledge we have, and that's what I will continue to do. I appreciate the time, and it's people like you that have gone through this school, that know this stuff, that help us do the things that we need to do. Alakwa.
Seems okay. Thank you very much for listening to this talk on what I think is an important topic. I speak today on the 8th anniversary of the beginning of the BP Deepwater oil spill, in celebration of Earth Day, which is Sunday, and also in honor of the rule of law, something under challenge in our country. Think to yourself whether you've visited one of the more than 150 designated national monuments. Many of them are now national parks. Congress has turned them into national parks, but people will have been to places like the Grand Canyon, Death Valley, the C&O Canal in Washington, Tetons, and Acadia National Park. So when you're thinking about them and seeing the beautiful photos, keep that in mind as we talk about the law. The statute was passed in 1906. You've heard the history from Charles Wilkinson. was a contentious statute at birth and thereafter, and so it's been litigated a number of times. The first decision under it was in 2013. The most recent decision regarding authority, and I'll get to that in a moment, was in 2006. So we've been litigating for almost 100 years. In addition, as you've heard, at least implicitly from the other speakers, there are now 6 cases pending. Then my talk is the backdrop to that. 5 of them challenging the significant shrinking of the Bears Ears Monument and the Grand Staircase Escalante monuments by President Trump. One, he shrunk to 13% of the size itself, Bears Ears, and the other to 50%, or as purported to. And also a pending case on the Northeast Canyons and Seamounts Marine National Monument, which is relatively near here, 100 miles off the coast of Cape Cod. And that's a challenge to the establishment of that monument by President Obama. I'm going to focus on decisions that are the backdrop for those pending cases. That is, the decisions that have been made about the authority of the president to establish monuments. It's a question of judgment what counts as a case, but I'm going to focus on the authority cases and tell you that there are approximately 13 cases that span close to that 100 years. Because I'm so short on time, I'm going to give you the punchline first of what courts have held, and then I'll go through as many of the cases as I have time for. The first, in every case, the courts have upheld the establishment of every monument that has been litigated. There has not been a challenge to presidential downsizing of monuments, though there have been some presidential such actions. There's no court decision about that yet. That's sort of stay tuned. Second, the courts have emphasized that the statute provides for the president in his discretion, and you can read that as in her discretion, we hope someday also, to declare a monument and reserve lands. The deference has been very significant to the courts. In the face of the proclamation has to recite the 3 essential findings. And I'm going to say what they are in a moment. And if the courts have said that if the proclamation recites those 3 findings, in general, there have been a few exceptions, but in general, the courts don't go behind that recitation. That's what it means to say in his discretion. The 3 provisions that there have to be and findings that have to be made, or that there's an object of historic or scientific interest. I will say other objects are specified, but that's the one that most attention is paid to. It has to be on lands owned or controlled by the United States, and it has to be the smallest area compatible with the proper care and management of the objects. As to these 3 findings, the courts have had a lot of discussion and rulings. They've been extremely clear from the beginning that object of historic or scientific interest, is not limited to archaeological or man-made objects. It can be ecosystems, it can be big areas, it can be the Grand Canyon. Second, for lands owned or controlled, that may include submerged lands, that is lands underneath the ocean, and may include waters on or over lands that are owned or controlled. It's clear that submerged lands close in to shore can be part of monuments. There's been no case to date that addresses the waters far out in the ocean, and that's the subject of one of the pending cases. The smallest area compatible, I can't find a case where courts have said it wasn't the smallest area compatible. The courts have made clear that if the president says it is the smallest area, that's enough. The court isn't going to go behind that finding. The courts note that the legislative history that you've heard from Charles supports giving a lot of deference to the president and supports establishment of monuments in the ways we've just said. The courts have emphasized the longstanding, what they call executive practice. That is, the presidents have done it for a long time and nobody's ever said no, and that's an important factor to the courts. They note in 1976, when Congress passed a law that basically reorganized public land laws, it specifically didn't change or limit the Antiquities Act. And finally, courts have emphasized that to do more, to have further review than this very cursory, is it in the proclamation, would amount to a clear invasion of the legislative and executive domains. In other words, it's necessary to maintain separation of powers, and a fundamental part of our Constitution. So that's what's been found. Now, how do the cases do this? There have been 4 Supreme Court cases. 2 go directly to authority, and 2 are relevant to the submerged lands issue that I noticed. The 2 that go to direct authority, the first one was in 1920, so it was pretty early on, and it related to the Grand Canyon Monument. It's a case called Cameron versus U.S. Mr. Cameron had what he said was a mining claim that turned out, he said, to be right near the top of Bright Angel Trail, one of the big trails that goes down into the Grand Canyon. And Mr. Cameron, using his mining claim, was charging people to use the trail, in effect interfering with their using the monument effectively. The Secretary of the Interior investigated and said it wasn't a effective mining claim. Mr. Cameron needed to stop. And the case in the Supreme Court is Cameron's challenging of that. So the Supreme Court upheld the Secretary of the Interior's finding that it wasn't a mining claim, but along the way, it made very important statements. The court said there's great scientific interest in this canyon. There is authority for creation of the monument. Ecosystems and large areas are here, and the court will not examine more than whether there is scientific or historic interest in the object. So early on, right off the bat, the Grand Canyon was okay. Second Supreme Court case was quite a bit later. In 1976, it was a case called Cappert. It was about Devil's Hole, which is a deep corner of federal land in Nevada, adjoining Death Valley National Monument, and it appears from the case that Devil's Hole was going to become part of Death Valley National Monument. It was protection in part for the endangered pupfish, as well as for other wonderful features. The pupfish needed water in the hole in order to survive. Somebody who was along the same source of water that fed that hole started taking water out of it, and it had the effect of dropping the water level in the hole, therefore making a problem for the pupfish. Lawsuits were brought. The court said, and this is important for those of you who have any grip on water law, which is a very convoluted thing, that the proclamation, what the president said, has the effect of including the reservation of unappropriate and impertinent water. In other words, if it was water that somebody didn't clearly have a right to, then the proclamation reserved the water for that. And it was also for waters located over federal land. It made clear that the Antiquities Act was not limited to archaeological sites. That was one of the claims, that it could indeed include ecosystems and natural areas. And there the court found that the Capperts didn't have any water right before the reservation of the monument, and so the monument got the water. So those are the 2 Supreme Court cases about authority. Then there were 2 cases about submerged lands, one called California versus the United States, which related to part of the Channel Islands National Monument off the coast of California, which is now a national park and a sanctuary and things like that, but it was protected then. And then a case called Alaska versus United States, which related to the Glacier Bay National Monument. Glacier Bay is also now a national park. The facts in both of these cases are far too complicated for my very short time here. But what matters in both is that the court said that submerged lands may be part of a monument, and that there's no question that the president had the authority to so declare them. In California, the court called these submerged lands as controlled by the U.S., not just owned, so that controlled part of the statute matters. And the important part of the cases is that monuments could be designated for submerged lands. Okay, so those are the Supreme Court cases. Now, I'm going to run out of time, and so rather than going through the other cases, I'll pick out a few highlights. The first case under the Antiquities Act was called Jefferson Lime Company versus U.S. in 1913. It was a case decided by a weird little court called the Court of Claims. But basically what was important about the case, though this wasn't exactly the holding in the case, is that it was a cave. It was a big limestone cave, and the court was clear with the fact that the president had authority to establish the monument for scenic and scientific interest. Second is State of Wyoming versus Frankie, one of the most cited cases. It's the District of Wyoming in 1945, and it related to Jackson Hole, which was proclaimed as a national monument in 1943, and I think is now the Grand Tetons National Park. Lots of discussion of the facts. The holding was something a little bit limited, but the court basically made clear that the president has authority to act for the judiciary to probe the reasoning which underlies this proclamation. In other words, beyond the face of the proclamation, would amount to a clear invasion of legislative and executive domains. So with a monument as significant as Jackson Hole, the court said basically if the president says it's okay in his discretion, it's okay. I'm going to I'll mention the Alaska cases because I worked on them. That was the first time I ever heard of the Antiquities Act. There was a long, complicated history of public lands under the Alaska Native Claims Settlement Act, but it caused President Carter to declare a large number of national monuments for big lands in Alaska in 1978, and the state of Alaska was not happy and brought suit. In the first case, the court said it's an action by the president. The president's actions can't be reviewed under the Administrative Procedure Act, and the president doesn't have to comply with the environmental impact statement requirements of the National Environmental Policy Act. The second one of these cases, Anaconda Copper, the court sort of said some equivocal things, but basically came down saying that there were a number of reasons he was going to find the monument at this juncture of the case fine. There are limits in the statute. There are those specific requirements, so there was no problem with delegation. The words of the statute are clear. The executive practice was clear. Congress didn't repeal it in the 1976 change statute. The Supreme Court cases were clear, and the legislative history was clear. It's a concise, short opinion, made clear what happened. And finally, let me mention, I can't see my time, but finally let me mention a couple of cases that were brought challenging some Clinton-era monuments, part of them because they're very interesting. One of them, Utah Association of Counties versus Clinton, challenged the Grand Staircase Escalante monument that you've heard about, and a district court judge in Utah, much, I think, to people's surprise but pleasure, really went through a very detailed analysis and basically upheld the monument and said, you know, there's limited review when it's the president under a statute that says in his discretion. The case got to the 10th Circuit, which found that there was nobody left with standing, and so it didn't make a decision. Then there were two big D.C. Circuit decisions, and these are the end. People challenged Clinton-era monuments in the District Court for the District of Columbia, which went to the D.C. Circuit. The first was a challenge to something called the Grand Sequoia National Monument, which was a national monument in California that protected trees to be managed by the Forest Service. In probably the clearest, most specific, if I would send you to anything, it would be this one decision by a district court judge in Washington, D.C., named Judge Urbina. He emphasized in his discretion, said the court is limited to examining the face of the proclamation. He went through the specifics. He went through the list of what the courts have held, which I just told you about, and he basically dismissed the case as having no factual allegations that support the claim. The D.C. Circuit upheld that decision in a slightly murkier but pretty on-point decision, and making clear that ecosystems could be protected. The companion case to that was a case called Mountain States Legal Foundation around the same time. These were all cases in the very early 2000s. Mountain States challenged 6 Clinton monuments. The district court, without even a written opinion, dismissed the case, and the Court of Appeals went through the analysis I just described for Tulare County and basically said there weren't facts that were alleged that would have any reason to overturn the monument, so the court dismissed the claim. So that's, in a very small nutshell, the history of the cases, and I think it is significant to note, as we are now litigating both the challenge to the, or being litigated, I'm not litigating, the challenge to the Northeast monuments, which is one of what are now 7 monuments in the ocean, and significant monuments in the ocean, some created by President Bush and some by President Obama, and the shrinkages significantly of Bears Ears and Grand Staircase Escalante. that the history of the cases and the reasoning of the courts will matter a lot. Thanks.
I'm going to try to set my timer, so maybe I'll stick within time parameters, but hold on for the ride, I guess, right? Because there's a lot of material to pack in here. I think the first point I want to make is that tremendous work went into the Bears Ears National Monument designation. And I want to walk through that a little bit with you so you can kind of understand that background. In 2010, spiritual and traditional leaders from the Navajo Nation formed Utah Denebakea and began interviewing local elders to identify the cultural resources of Navajo people in the Bears Ears area. This led to an interview of 70 individuals. And in this process, UDB was able to identify over 100,000 historic landmarks, structures, and historic and scientific objects that were located in the land that became Bears Ears National Monument. And those included migration routes, ancient roads, great houses, villages, hogans, kivas, and rock painting, as well as rich paleontological and ecological resources. So bottom line, for Navajo Nation and for the 5 tribes of the coalition, and actually a dozen tribes or more, these lands are incredibly culturally rich and dense with resources. And because of that, this research demonstrates that all of these lands within the monument boundaries were necessary for the proper care and management of these important cultural and historic resources. To go back to the process that was happening in Utah, Senator Bennett had launched an initiative and a discussion really about how do we protect these lands? What's the proper way to do this? There was some debate, and all of Bears Ears National Monument is located within San Juan County, which is in the southeasternmost portion of the state. And so there's a rich debate. Many proposals were reviewed. National Park was considered, a conservation area, national monument. And eventually, the leadership in San Juan County and state officials, congressional officials, felt like it made more sense to come up with a legislative solution. But leading up to that, there was a vote in December of 2014 where the various proposals were presented to San Juan County population. And actually, the Bears Ears proposal presented by the tribes was supposed to be one of the options, but the county at the last minute decided to take that off the list of options. And so there was a write-in campaign, and even with the write-in campaign, 64% of comments were in support of the tribe's proposal. But instead, the county and the congressional delegation chose to go with the Public Lands Initiative, which received only 2 comments of support, which was less than 1% of the total comments. But because of this, the tribes felt like, okay, let's work with the delegation and see what we can come up with to protect these resources. And President Obama also wanted to give the congressional effort an opportunity to move forward. And at that time, the 5 tribes really came together to form the coalition in 2015 and tried to work with the congressional delegation. There wasn't a lot of progress in that. The bill was introduced, but it included numerous poison provisions, pills, including, for example, the attempted transfer of 100,000 acres of the Ute Indian tribes' Uncompahgre Reservation to the state of Utah for fossil fuel development. So it was unable to attract the support of the tribes, and then also of any co-sponsors beyond Representative Bishop and Chaffetz from Utah, and the initiative failed. So it was then that the tribes turned to President Obama and said, we really need these lands to be protected. At that point, the cat was sort of out of the bag. People nationally, internationally, we're starting to learn about the richness of the resources at Bears Ears, and the amount of visitorship increased, thus increasing the urgency to protect these lands. And so the Obama administration put in an inordinate amount of time and expertise in conducting research, reaching out to the public, and developing its position on bears' ears, and tried very hard to come to a proposal that would balance all interests, not only of the tribes, but also of the county officials and strong opponents to the monument who had utilized those lands as they pleased, more or less, for quite some time. There was very strong pot digger culture in the area, but on the other hand, there, of course, was the interest of the tribes of wanting to protect those resources, prevent pot digging, prevent grave robbing, things of those nature. So in the end, this extensive process went underway. The secretaries for Ag and Interior went out and visited Bears Ears, met with people, actually had a public hearing. There were over 2,000 people who attended this public hearing. It was the largest gathering in Bluff, Utah, actually. People were randomly selected to provide comments. And at the close of this process, an extensive record, on December 28th, 2016, President Obama designated the Bears Ears National Monument, and that was just an incredible moment for everyone who had put in the effort and the work. Our advocates, Charles, and if you could just give them a hand, it was amazing. And the Monument Proclamation was really unique for a number of reasons. One was it was the first time tribes had come together and really pushed for a national monument to protect our resources, and to do so in a way where we were determining and deciding, playing a role in how those resources would be protected and managed, so that we could ensure that it was culturally compliant, essentially, and done so in a manner that wouldn't adversely affect our communities, and then also would preserve what needed to be preserved going forward for the next generation indefinitely. That was one unique factor, and then the other unique factor was that President Obama ensured that the historic uses with respect to the land could continue, whether they were traditional uses by the tribes or even to a significant extent traditional uses of non-native Utah citizens. And this was written into the monument specifically. And then the final thing that was really impressive and of course, drew the greatest interest from Navajo Nation was that, the tribes would be part of a commission, and that was how they would work with the federal agencies to ensure that management was handled properly and done so culturally consistent. And so, there was a lot of excitement about that, and then we had a new administration come in and had a very different view on the protections of the Bears Ears National Monument lands. President Trump certainly was in close contact with the Utah delegation, Senator Hatch, and there was a strong lobby from Utah to open up preserve the opportunity for natural resource extraction on these lands. And so the administration undertook an extensive review, and you could see that in the New York Times records release that came out recently. And so the administration undertook a review. President Trump requested specifically a review by Secretary Zinke to identify, basically to review all national monuments where they were larger than 100,000 acres or where the Secretary determined that designation or expansion was made without adequate public outreach and coordination with relevant stakeholders. In the case of Bears Ears, apparently the tribes weren't relevant stakeholders. But moving forward, so just to summarize that process, the San Juan County Commissioners had an open door with Secretary Zinke. They met multiple times leading up to May, when the secretary issued his report making recommendations. The tribe sent multiple letters, the coalition sent letters, and those were not responded to. It wasn't until Secretary Zinke came to Utah to do his 4-day tour with San Juan County officials mostly, but also state congressional folks, that at the very last minute, they added on an hour meeting with tribal leaders. And so, we all scrambled to be there and shared our views. The Secretary was spitting out the talking points of the commissioners, county commissioners. It was a very interesting meeting. And then gave them his ear for the next 4 days, and ultimately made a decision that was not favorable to the tribes. It reduced the monument. Actually, it revoked and replaced the monument. The reduction was so extreme, only 15% of the original monument remains. And I am running out of time rapidly. The proclamation, the Trump proclamation, does much damage to the original monument. It's almost night and day in terms of the amount of land that's protected, as well as the management methodology. The voice of the tribes is totally suppressed. The president himself makes the decision on who represents the tribes on these management commissions. The commission is no longer consisting of representatives from the tribes. It's a mix of county officials, state officials, and some tribal leaders. It doesn't even allow representation from the full 5 tribes. In terms of our complaint, as soon as the proclamation was issued on December 4th, we filed a suit the same day and raised a number of arguments, essentially in a nutshell, arguing that this proclamation was unprecedented, and it was a revocation, a replacement of President Obama's monument, and unlawful. It seized an authority that the Constitution vests in Congress only through the property clause, and exceeded the power delegated to the president by Congress, and indeed argue that under the Constitution, essentially, the president's violating separation of powers and aggrandizing power of the legislature, creating new law, allowing him to revoke or modify monuments. And of course, our first claim is rooted very strongly in the Antiquities Act. And I have a lot of really great history here, but you've heard much of that. And it's not just the Antiquity Act, it's subsequent laws, an Attorney General opinion, the Federal Land Management Policy Act, recent cases and arguments set forth by the United States. Second claim was our separation of powers claim, third claim, property clause, and then, of course, wrapped up with an APA claim. And there are 2 other lawsuits. One is led by Utah Denebakea, as well as Patagonia, Friends of Cedar Mesa, Conservation Lands Foundation, the Society for Vertebrate Paleontology, National Trust for Historic Preservation. They argue that reducing the monument threatens hundreds of archaeological sites and objects and will damage business for the outdoor industry and will cause harm to paleontological resources. And then the third lawsuit is Natural Resources Defense Council versus Trump. That includes a whole bunch, I think it's 14 environmental organizations, and they argue that reducing the monument threatens archaeological sites and objects and will cause harm to paleontological resources. And currently the case is before the District Court of D.C. There was a motion by the United States to transfer the case to Utah. Of course, we objected to that. I did miss a step. First, there was a consolidation of the case, and we agreed to that under specific terms. And then we've been responding to the request to transfer, waiting for the judge to rule on that. So that's pretty much where we are right now. And as soon as the judge rules on that, there's going to be a flurry of brief drafting. I think the United States gets 7 days, and then we respond. And so that's that. Thank you all.
Thank you. Short on time. Our students are going to talk really quickly about the wonderful work they're doing, and then we want to take questions.
Hi, I'm Caroline Cox. I'm a 3L in the clinic, and So as you've heard a lot about Bears Ears, but Trump also required review of approximately, I believe, 27 national monuments. So this fight is a lot bigger than just Bears Ears. And in fact, in addition to shrinking Bears Ears, he shrunk Grand Staircase Escalante National Monument. So as a student in the clinic, I've been writing 2 amicus briefs from the perspective of local government officials who, although signing on to amicus brief in their personal capacity, have really seen how the national monuments have benefited the communities in Utah. There's a lot of data that I found that shows how national monuments actually support local economies. While the Trump administration has, throughout this process, definitely shown some favoritism towards mineral extraction and natural resource extraction, the economies that kind of emerge from these protected public lands often offer more diverse economies that are more stable. So my amicus briefs for Grand Staircase Escalante and Bears Ears really focus on that perspective and kind of providing a counterpoint to the narrative that I think the Trump administration has been particularly good at putting out, that kind of says these local concerns really push against the monument. And obviously, as we've heard today, communities near the monument care very deeply about it, and some of these elected officials care very deeply about it from an economic standpoint and from reliance on these national monuments.
Hi, my name is Iris. I'm a 2L in the clinic, and we're just going to take a very quick tour of a marine national monument. It's local to here. It's called the Northeast Canyons and Seamounts Monument, which is 130 miles off the coast of Cape Cod. And it was the first national monument designated in the Atlantic Ocean by President Obama in September of 2016. And it's a really, really special area of the ocean because there are these really deep underwater canyons and really tall underwater mountains. And people have actually called it Dr. Seuss's Gardens because there are these giant, beautiful, deep water corals that grow to the size of trees in multiple colors, and they can live up to 10,000 years old. And because of the unique topography of the area, it's where a lot of different animals come to feed, like endangered whales and tuna, and my favorite, which are seabirds, like puffins and terns. So not everyone is as excited about this monument as I am, especially commercial fishermen in New England. Even though they don't do a lot of fishing in the area historically, they feel like it's President Obama's attack on their way of life. So shortly after this monument designation, they filed a lawsuit in D.C. challenging President Obama's authority to create this monument in the middle of the ocean. So there was actually a stay on this litigation for about a year because of the Trump review of monument designations, but that stay was lifted last month, and now they're going ahead with the litigation. So what we've been doing in the clinic is we've been representing an environmental group as an amicus to this litigation, and we're arguing that this monument is very important to seabirds like the puffins and the terns, and that the boundaries drawn by President Obama are the smallest area compatible for their protection as required by the Antiquities Act. So luckily for us, on Monday, the Department of Justice put out their motion to dismiss, and it was a pretty strong defense of this monument. They argued that the size of the monument is appropriate, and President Obama did have the authority to designate it. But we don't think the litigation is going to be over because this area is very rich in fish and potentially oil and gas. So I think it's definitely an active area of litigation to look out for in the future. Thank you.
So thanks to all of our wonderful, wonderful speakers. I know we're running out of time and some of you need to leave, but we're here to answer questions. So please raise questions and tell us to whom you're addressing your question. There have to be questions.
You're so thorough.
Yeah.
But we can hang out up here.
No questions at all? Okay, yes.
I I just want to say thank you to the panel for raising such important issues. I was born and raised in southern Utah, so I'm very familiar with the area. And as far as protecting environmental lands, a lot of times in Utah the conversation gets split between conservative values and liberal values. And especially when the political climate in Utah is very conservative, how do you reach across that political divide to make sure that everybody understands how the lands impact everyone, regardless of your political viewpoint?
How do we reach across the table? I think what we've found is a communication. Again, you're looking at 5 tribes that normally don't work together on issues of this nature, because even when we're talking about archaeological sites or certain ancestral lands, we sometimes clash even as tribes. But I think what this is a continuation of efforts that we've taken for not only Mount Taylor, Grand Canyon, Escalante. And here's a funny story about the Grand Canyon, Escalante stuff. When we were in the Navajo Nation Council chambers, it was during Halloween, and this legislation was coming up. So myself and my head councilman were there to represent Zuni. And at one point in time, we see somebody approaching the gallery, and they sit down, and we're like, well, who is this person? And I look across, and underneath it says Attorney General, but this person's wearing face paint, and it's Ethel Branch. She was at our office at some party, I believe, and then she got called to the council chambers. She entered, and of course it's very formal. So when she entered, they gave her the mic, and there she was in face paint talking. But all that aside, you're essentially correct. I mean, the community engagement is definitely on there. But what our issue was with the Trump executive order was the fact that a county commissioner was designated as to be at a seat with the tribal leaders. When we felt that as tribal leaders, we should be able to approach the county commissioners or any other organization as I guess as the coalition or as the commission, to try to make sure that we understand and educate on what the intent behind the national monument is. Because when we're looking at access to natural resources, firewood gathering, all those other things, we want to make sure that the tribes will continue to have access to those things with either limited or no permitting other than what we agreed will be the proper way to do that for the management of these resources. We always understand that we always want to make sure that hunting still goes on, recreational activity goes on, but we want to make sure that on the educational aspect, you know how to visit these areas properly and correctly without disturbing ancestral remains or traditional cultural properties.
I would add that my general advice, and it's very general, is that you've got to get out of the general and get to the specific. So that if you get people to sit down and say, well, what matters to you? What matters to people is their kids get educated, that they have opportunities to advance. If you get it out of the postured situation and into something specific, you may have a little more opportunity to make common ground.
And I'm going to come up here to pour, I don't know, just to basically say it is incredibly challenging in San Juan County in particular. The nation has been suing the county since the 70s to ensure that equal distribution of public resources makes it to the Native American population, which is over 50% of the county. We had to sue them to bring schools onto the Navajo Nation. Our kids were having to ride buses, and Charles worked on this litigation actually, 2 hours one way just to get to school because the county refused to build schools on the nation. And we're still suing them over voting rights litigation. There's been a long legacy of that. We had a recent ruling in 2016 that the county commission and school district boundaries were racially gerrymandered, and the county has fought us every single step of the way. So they're appealing this case to the 10th Circuit. We expect they'll appeal it to the Supreme Court when they lose. And so it's incredibly challenging. What we've encountered with Navajo Nation is quite an interesting development, something that we've not really experienced in the past that I can think of in terms of The county official, not the county, the state officials and the president even and federal officials saying, well, Utah Navajos support the reduction of the monument. They don't want the monument. And we have to explain that, we have elected leaders. The president speaks for the nation. County officials, there's a county official who's Navajo. She's not elected by the Navajo people. She may have some constituents who are Navajo, but she is not a spokesperson for the nation. Our leadership that's elected through Navajo law, pursuant to Navajo law, is our spokespeople. And, we have 7 of the 8 chapters within Utah, that's sort of our county, more or less, equivalent for the nation. All of them but one have voted in support of the monument. And one of them, where this commissioner is from, she's actually prevented the vote from happening. So anyway, it's incredibly complicated, and it's been hard to get direct communication. Representative Curtis, who we were very hopeful, who replaced Jason Chaffetz as representative in Congress for San Juan County, seems like he'd be a great person to work with, seemed willing to communicate with tribes. But the first thing he did immediately upon being elected was introduce legislation that would congressionally ratify the Trump reduction. And we've met with him, and he has said, tell me how I can make the bill work, how I can make it better. And it's like, we're just on different planets, and there's no, we've told him repeatedly, withdraw the bill. If you want to work together, we can work on something together, but you need to withdraw that bill, because that's not even a fair starting point. You'd have to completely rewrite the bill in order to get it to be something that would be acceptable to the tribes. And so it's incredibly challenging in San Juan County in particular.
And thank you for asking a great question, because as you can tell, it segued into a great conversation. And you're absolutely right. How do we do this? And one of the things is we continued from day one as a group of 5 tribal nations to extend that courtesy and respect to each of these leaders, from the county level to the state legislatures in Utah and into D.C. as well. And the only thing we can do is do what we do best as Native Americans, and that's continue to be courteous, continue to be respectful, and ask them to the table. And you don't know how frustrating that can be, but we will not stop asking, because we want to see the whites of their eyes. We want to see the whites of your eyes. We want to hear you. In order for you to understand us, then we need you at the table so we can understand you. And that was a lesson that Rob Bishop shared with me, because it wasn't until I literally got to see him across the table from me and share his thoughts and views, then I knew that this bill, the legislation, this whole interaction was not going to work. At that point, we knew where we stood as Native Americans, bringing an issue this important to the discussion, that we were going to have to use the executive branch to get the protection, further use of this land for all of us, because it was just something they were not willing to negotiate, which I always thought as a part of the democracy is coming to the table with an open mind to be diplomatic and reach a negotiation. And that's what we need to do, is just continue to strive for those discussions and negotiation so we all can live together and be better partners, be better stewards of the land, but continue to be respectful of one another. Yes. No. It was so touching. Let me sing a different song, okay? And I'll just listen really quick.
Come on, see the live out down the Zuni in there. December.
oh, hey, hey, oh, hey, oh, hey, oh. Thank you.
All right, so yes, we are out of time now. If you have more questions, please come down and you can speak one-on-one us at the end. Just I want to say thank you all for joining us very much today, and let's have another round of applause to thank our speakers.